Hello and welcome back to Insights International. Today we shall be talking about international human rights law, but before we proceed, remember to subscribe and hit the notification bell to be notified on future uploads. The term right is a contested topic of discussion in international law. Some rights are binding commitments or protections immediately available to the right owner, while others specify possible future patterns of behavior. According to the Vienna Declaration and Programme for Action of 1993, human rights are the birthright of all human beings and their protection is the first responsibility of governments. What are rights? In abstract terms, rights refer to justice or ethical correctness. It can be consistent with the rule of law, morals, or principles. Rights can also be power, privilege, or demand inherent in one person and incidental upon the other. Human rights are characterized as 1. Inalienable. That means that they cannot be taken away. 2. Fundamental, meaning that they are inherent by you being human. 3. Universal. They apply to all human beings all over the globe. 4. Egalitarian, meaning that they are classless or the same for everyone. Human rights norms exist as shared norms of actual human moralities, justified moral norms supported by strong reasons, legal rights at the national level, civil or constitutional, and legal rights within international law. Let's now look at scholarly views on human rights, their nature, and their characteristics. The first view is legal positivism. This view regards human rights as entitlements that have become part of a positive legal system. This means that human rights derive their legitimacy from the will of the state or the sovereign. This can, however, be problematic, especially from despotic states that violate human rights. Natural law thinkers, on the other hand, see human rights as inherent and correlating with nature. According to them, human rights cannot be derogated except for a few exceptions. It is therefore important to note that international human rights law is a law concerned with two things: promotion of rights of the individual, and protection of these internationally guaranteed rights from breaches. How are human rights classified and categorized? The classification of human rights was derived from the 1948 Universal Declaration of Human Rights. Human rights were classified into two broad categories: civil and political rights and economic, social and cultural rights. These two main classes were later translated into international covenants that were legally binding in 1966. These are the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. Let's begin with civil and political rights. Civil and political rights can also be referred to as first-generation rights. They are negative rights preventing abuse of power by states towards individuals. They include but are not limited to the right to self-determination, freedom from torture and inhumane treatment, right to life and freedom from slavery and forced labor. On the other hand, economic, social, and cultural rights can also be referred to as second-generation rights. They are positive rights placing a duty on states to support individuals achieve their rights. They include the right to work, right to fair remuneration, right to collective bargaining, right to join or form trade unions, right to education, and right to own property. First-generation and second-generation rights are subject to the principle of indivisibility and interdependence. This means that the two classes of rights could only successfully exist in combination. They are mutually inclusive. Without civil and political rights, the public cannot assert their economic, social, and cultural rights and vice versa. There is also a third classification of human rights known as third generation or solidarity rights. These rights were birthed from the International Covenant on Economic, Social, and Cultural Rights of 1966 philosophy, which requires states to cooperate economically and technologically, to achieve development and full realization of rights. Such rights include right to self-determination, the right to enjoy group processes or institutions, the right to development and the right to peace. That is it for today. In our next video, we shall be analyzing the prioritization of rights and the emergence of modern human rights concepts. Thank you for staying tuned.